I'm Beau Johnson. It's December 31st, 2025. Welcome to YesToHellWith.com. People are taught to believe that justice flows from the person wearing the black robe. That belief is the first and most damaging mistake that we make. In the modern American legal system, the judge is not the source of authority. The judge is the operator of a pre-existing apparatus. Historically, justice depended upon the character of the person deciding the case. Wisdom mattered. Discernment mattered. Conscience mattered. That is no longer how the system is designed or how it operates. Today, outcomes are not produced by moral reasoning. They are produced by procedure. And this shift is not merely philosophical, it is operational. Modern courts process an overwhelming volume of cases. To keep the system moving, judges must act with rigid efficiency. Speed, output, and docket control are not incidental pressures. They are structural requirements. This fact alone calls judgment and fairness into question. A system that demands efficiency at scale cannot also demand careful moral discernment in each and every case. These two are incompatible. Justice requires time. Truth requires examination. Efficiency requires compression. So the system resolves the conflict by removing justice and truth from the equation. If an objection is not raised at the correct moment, it is waived. If jurisdiction is not challenged immediately, it is presumed. If the record is not preserved, the issue does not exist. If silence occurs, consent is inferred. None of this has anything to do with justice. None of this has anything to do with truth. These are mechanical consequences. This is why a claim can be factually true, legally sound, and morally correct, and still fail without ever being examined upon its merits. The judge does not ask, "Is this right?" He does not ask, "Is this true?" He asks, "Was this raised properly?" This distinction changes everything. Authority does not flow from the bench, it flows from unchallenged presumptions. The judge merely enforces what the system assumes to be true already. And this is why the modern legal system does not fail because judges lack virtue. It succeeds because virtue is unnecessary. Judges are drawn almost entirely from the same professional class as lawyers. And lawyers are not trained to pursue justice. They are trained to master procedure, deadlines, rules, standards of review, waiver doctrine, preservation of error. This is how professional competence is measured today. A lawyer who challenges the machinery too directly is punished. A lawyer who appeals to equity or truth over process is dismissed. A lawyer who keeps cases moving smoothly through the system is rewarded. When judges are selected from this pool, the system gets exactly what it wants. Not philosophers, not moral arbiters, operators. The judge's task is not to weigh fairness. It is to verify whether procedural thresholds have been crossed. Late filing? Denied. Unpreserved issue? It does not exist. Jurisdiction unchallenged? Presumed. Improper form? Fatal. This is assembly line justice. Inputs are standardized. Rules are applied. Outputs are produced. The personal character of the judge is irrelevant. Equity still exists in name, but not in function. It has been boxed, bounded, and neutralized, allowed only where it does not threaten institutional finality or disrupt efficiency. This is not corruption in the crude sense. It is something more dangerous. It is design. And design reveals intent. A system that operates this way cannot be about justice. It cannot be about truth. And it cannot produce fairness for a supposedly free people. Fairness requires inquiry. Truth requires confrontation. This system requires compliance. That leads to an unavoidable conclusion. When an institutional structure consistently produces outcomes through presumption, waiver, procedural foreclosure, and enforced silence, when it benefits from speed over substance, when it insulates itself from meaningful challenge, and when human consequences are treated as collateral, it is no longer a forum of justice. It is an absolute racket. And when a racket is maintained through coordinated roles, repeat procedures, institutional incentives, and predictable outcomes, the conduct ceases to be accidental. It becomes systemic. What the people face is not the occasional failure of justice. It is an organized method of processing lives while avoiding truth. And in that reality, fairness is not merely unlikely, it is impossible. This is why people then ask the inevitable question: what about the men who suffered? Norris, Waller, Ingalls, Webb, and many others like them. They were not reckless men. They were not violent men. They were not predators. They were men whose lives were processed by a system that does not weigh intent, conscience, or proportionality, unless those things are procedurally allowed to be seen. In these cases, the judge did not wake up intending to destroy a man's life. They did what the system allowed them and trained them to do. They enforced waiver, they enforced presumption, they enforced procedural posture. They enforced what was before them, not what was true. Once jurisdiction is presumed, it was never revisited. Once intent was administratively inferred, it was never weighed. Once discretion was foreclosed by procedure, it was no longer available. These men did not lose because a judge was cruel. They lost because the apparatus had already decided what mattered. By the time the human being appeared in the courtroom, the outcome had already been narrowed to technical compliance. This is the quiet brutality of the modern legal system. Not malice, not hatred, but indifference enforced by structure and protected by design. And here is the final observation. When we apply the four corners of justice diagram, we do not see one actor denying justice or truth. We see that given the structure of injustice, all participants are encouraged and often compelled to support the racket. Investigators are rewarded for charging, not restraint. Prosecutors are rewarded for convictions, not truth. Defense attorneys are rewarded for efficiency and plea resolution, not disruption. Judges are rewarded for docket control and finality, not moral inquiry. Each corner is incentivized to move the process forward. No corner is designed to stop the machine. Each corner is designed to keep it running. Within this construct, truth becomes inconvenient, fairness becomes destabilizing, justice becomes a threat to output. So injustice does not require malicious intent. The system supplies the pressure, the system supplies the rewards, the system defines success. Participation becomes compulsory. To resist is to risk career damage. To slow the process is to invite sanction. To insist on truth is to be labeled disruptive. This is why the four corners of justice diagram does not reveal a failure of individual morality. It reveals a coordinated structure that normalizes injustice while diffusing responsibility. No one actor appears culpable, and yet the outcome is always the same. Lives are processed, truth is bypassed, fairness is foreclosed. Justice is no longer something a judge creates or ensures. It is something the apparatus allows or denies based upon compliance. Once we understand this, we stop appealing to conscience. We stop arguing substance to a system that only recognizes sequence. If you do not understand how authority, presumption, status, or standing are created, the apparatus will decide for you, and it will destroy you. And once you see the machine, you stop mistaking the operator, the judge, as the source of power. This is where leverage begins. And as always, may truth reign supreme.